but I'm just going to restate it for those that might not have. Okay, looks like we're now being live streamed, which is wonderful. And that even means we have to behave even more. Even though we're off the official PRC record, we're on the internet worldwide, I believe, on YouTube. Anybody with an internet connection can be watching us, so we'll be on our best behavior. But we're off the records, and the things I want to discuss are some protocol for the Zoom hearing today. This is a hearing. This is a formal hearing, if you will. I do prefer to have a video of everyone. It makes us feel closer, but there are other reasons. If I have to judge the veracity of a witness, I certainly like to see that witness. And I think it's just good for us all. It brings us together a little bit, and I really don't like looking at a screen that says something like EPE IT support 2 or something like that, if possible. And I like to know who's there, and if I see their face moving, it helps. Every once in a while, I have lawyers that forget to turn off their mute, and they're talking, and I realize they're objecting to introduction of evidence or something like that, or some testimony or some questioning, and they're trying to make an objection, and I can't hear them, of course, but if I can see their face moving, I know that they're making an objection. So that's actually pretty helpful to see everyone. Oh, there's a smile from EPE IT support 2.
We just have three computers that we use just in case we have to bring a witness on.
Well, that's a really cool digital delay box you've got hooked up to your computer.
Thank you.
A little bit like Darth Vader on the in the Starship Enterprise or something like that. And
Echoing. Sorry.
I do recognize you from other hearings. And who is on the EPE IT support box? Who is that?
It's the same. We just have three in case we have to bring a witness on.
Okay, if you can do anything to stop that echoing, it could be that you also have the internet feed off of YouTube at the same time. So if you do, turn that off because you've got the direct. You don't need that internet thing, okay?
Okay, got it.
Can you switch that off now and we'll see if that echo goes away?
Yes.
How's that? Can you say something?
Yes, but I think it's still echoing. Not sure why.
Okay, that's better.
Let me turn.
All right, thank you. If you can work on it a little bit, that would be helpful. So let's just wait another few minutes. Another thing is we have Ms. Gonsalves with us today. She's a court reporter, and she's already put in some time on this case. I actually tried to avoid having to use Dropbox or any other kind of system because basically everybody was served with essentially, as far as I know, everything that's to be admitted in this case. So there wasn't any real reason to use Dropbox. However, Ms. Gonsalves was probably the reason, and I wanted to get her the exhibits in advance. And so she already put some work in getting the exhibits. This case is going to be relatively simple. I don't expect much cross-examination, or let's just call it examination, if any. I like to clarify any ambiguities I might detect. This is, of course, a stipulation case, so it's a little different than a case on the merits. So far, we've discussed procedural matters. We have not started the record. Ms. Pleasant, how you doing? What do we have going? Can you speak? Okay, now I'm not getting any audio from you.
She had muted herself.
Yeah, but she looks unmuted on my box. Thanks, Ms. Stevens.
Oh, yes, sir. I'm sorry.
Okay, you there?
Is it clear now? Can you hear me?
It's tons and tons better, absolutely better.
Oh, thank you, sir.
Yeah, I think you could sell that that digital delay to a lot of musicians. They like that kind of stuff.
Oh, with the extra voice.
Yeah, you're gonna have to box it up and put it in a little box with switches on it.
Oh, great. Thank
Okay. It's now 10:10 and I don't want to start too late. We're like I said, we are on YouTube and I'm sure well, I'm not sure, but there could be people that have tuned in and want to have this hearing. Is anyone opposed to going on the record at this point?
I have one
No.
question.
Yes, ma'am.
Am I swearing in the witness or are you swearing in the witnesses?
Well, if you don't mind doing it, that would be
Oh,
wonderful.
I don't mind. I just forgot last time, so I want to remember. I just want to know so that I can help interrupt and do that.
You can't see, but right at the top of my page here, it says swearing.
Oh, okay.
And that's not cursing. That's to remind me to swear in the witness. Every once in a while, I do forget. And what I'll do is at the end of the testimony, swear them in. And I believe it's possible to do that. I have an idea that they could all be sworn in at one time.
Sure.
So I don't have a problem with swearing them all in at one time. I'm a little goofy and I like witnesses to stand and I stand up, but then they end up looking at my belt buckle while I'm swearing them in, which is also a little bit weird. So I would rather you do it rather than me do it. And they probably would rather you do it rather than me do it.
So do you want me to do a group oath then?
Yeah, I think so. We'll do that right at the beginning, right after we do some preliminary discussion on the record.
Okay.
Okay. Miss Olson, who is sitting next to you? I believe I know already, but who is that?
Jim Schiestel with EPE.
Oh, I was wrong. So I apologize. Can you say your name again and spell it, please?
Certainly, it's Jim Schiestel, SCHICHTL.
I was right. I'm sorry. Thank you, Mr. Schiestel. I thought that was you. I think I've only seen you in one other preliminary hearing that we had on a case. Okay, I think it's about time to go on the record, okay? All right, on the record.
Examiner, this is Anastasia Stevens for the city, and I think Harry Olson for the company has the same issue. I know you just mentioned swearing in the live witnesses simultaneously, but how would you like to enter into the record the testimony of the witnesses who aren't testifying here today? And that's Ms. Rock for the city and Mr. Gomez and Mr. Gonzalez for the company.
That's one of the things, and I'm glad you asked, and it's something I thought that I should discuss on the record. Isn't it, don't the parties have an agreement to waive cross-examination of the witnesses who did direct testimony? Is that in this case? So Mr. Black is acknowledging that. Ms. Stevens, is that correct?
Sort of. I think we basically are waiving all cross-examination prior or live witnesses, except for in response to your questioning, because we're not opposed at this point.
Yeah, of course, it's a joint. It's a joint stipulation. I get that, but I just before we went on the record this morning, I was digging through not only my file but digging through my emails to find that in writing, and I remember it in my mind. We probably discussed it somewhere. But I couldn't actually find it in writing, and that's why I wanted to verify that with you guys. And I thought it'd be good to put that on the record rather than just informally before the hearing. So I'm going to ask whether there is an agreement between counsel, including Ms. Souls, pro se litigant, to waive examination of witnesses other than any redirect concerning any questioning I might have. Is that an agreement with all counsel? If it's disagreement, tell me now.
I agree.
I think
Agreed.
Okay.
there's agreement to that. And I think, if I recall correctly, we had all agreed to stipulate to admission of the direct testimonies of those witnesses that have been excused from the hearing today. Is that correct?
I believe to agree to the admission of the written direct testimony of all witnesses. But there are witnesses in support of, let me see who we've got in support of the stipulation, make sure they're here. We've got Mr. Chavez. Is he here? Yes, he is. Okay, we got Mr. Provencio. He's here. We've got Mr. Martinez, Chuck Martinez. He's here. Great. Mr. Sheetzel, he's here. Ms. Souls is here. So that's all the witnesses that presented direct testimony in support of the stipulation. They are here. So if we all agree to admit their testimony, that's pretty easy, unless I have any questions. And the next thing, which would entitle you to do some redirect, but my next question is, excuse me, right? I was thinking of two things at once. It's always dangerous for me. Yeah, I don't have any other questions. So I'm going to put that stuff on the record. You can't see my my crib sheet, but right under where it says waive cross-examination, it's admission. Oh, I know what I wanted to ask. I believe it's within the because of the nature of this case, we should identify each of those pieces of evidence individually and mark them and put on the record how they are being marked, and then move for admission. And of course, there being no objection, I'm going to admit them. I'd like to go through each one of those, and at that point, they will become part of the record. That's the procedure I intend to follow. I mean, we could do it en masse, so to speak. It would save time, but this whole business I am in is not about saving time. It's about being very methodical. And that's the nature of proceedings before the PRC, and it's the nature of my cases. So I'd rather be very methodical, identify each exhibit, label each exhibit, and then admit them there unless there is some objection. There won't be any examination on the direct testimony. There won't be any cross-examination on the direct testimony. I may have examination on the testimony in support of stipulation. All right, before we go on record, is any questions about all of that stuff? Okay, once again, we've been on YouTube up to now, but we haven't been on the record. All right, I'm ready to go on the record because it's 10:17 and we're actually running late. Ms. Gonsalves, please start the record at this point. Good morning, everyone. It is 10:17. I apologize for starting this hearing a little bit late. We have had discussions off the official record. They've been only procedural questions. There's been no questions concerning the merits of this case. Is that correct, Ms. Olson?
Yes.
Ms. Stevens, only procedural questions before we went on the record?
Yes, sir.
And Mr. Black, is that correct?
I have no procedural questions.
But before we went on the record, we were only having some procedural discussion, correct?
That's correct.
Okay, thank you. And Ms. Sauls, is that correct? Thank you very much, Ms. Sauls. She's nodding her head even though I can't hear her. Is that correct?
That's correct.
All right, thank you and welcome. Good to see you. This case is, for the record, this is case number New Mexico PRC 21-00111-UT. The case is captioned, in the matter of the application for approval of El Paso Electric Company's 2021 Renewable Energy Act plan pursuant to the Renewable Energy Act N 17.9.572 NMAC and the fourth revised rate number 38 RPS cost rider. Wow, quite a caption. That is the case before us today. This is an annual filing and it's concerning Renewable Energy Act. This case is somewhat expanded, if you will, but we'll get into that if necessary. It's because it's an annual case, it refers back to other proceedings in previous cases, and that's part of the nature of this particular proceeding. The parties, let me mention a few other things as my preliminary introduction. The parties have jointly filed a stipulation. So this case comes under procedural rule 1.2.2.20A3. which indicates that upon the receipt of a stipulation, which the commission received a stipulation, which would settle the substantive issues. In this case, settles the substantive issues with the exception of two issues which are deferred, which is in fact a settlement of those substantive issues. The commission or the presiding officer, that's me, shall, I have no option, conduct a public hearing to determine whether this stipulation should be approved by the commission. And that's why we're here today. That's why I'm here today, and that's why you're here today. That section goes on to say that the proponents of the stipulation, and this is a jointly proposed by all the parties. So it's you're all proponents of the stipulation, have the burden of supporting the stipulation with sufficient evidence and legal argument to allow the commission to approve it. So I kind of circled the word "and." Evidence would, of course, be the testimonies in support of the stipulation, which has been filed, and I presume that will be admitted in the evidence. But that's not exactly legal argument. So in order to satisfy the regulation, I would ask that council just make some sort of closing argument that they have satisfied their burden of proof. It's a joint burden proof. You could argue that it could only be made by one council, but just to dot all the I's and cross the T's, I'd like to hear a few words from each council that they have satisfied their duty. Now, what is that standard of proof? The standard of proof that I expect to accept evidence on, and which I'll require to certify to the commission that they should approve the stipulation, is that the stipulation is fair, just, reasonable, and in the public interest. Now, there is evidence in the proposed testimony in support, which isn't quite evidence yet until it's admitted. When the commission is deciding whether the stipulation is fair, just, reasonable, and in the public interest, which is what I'm looking for, the commission typically looks for, and we lost Mr. Chavez, he must have got bored. They're looking for whether there's been serious bargaining by capable parties. In other words, arm's length bargaining, informed parties. I believe everyone here is quite sophisticated, and there is testimony that it was serious bargaining. I mean, it certainly looks like it was serious to me at this point from what I've seen so far in the proposed evidence. I can't consider it until it is evidence. That's why we're going through this process of admitting it. The other thing to look at is that does the stipulation benefit ratepayers, and that there's benefits for ratepayers and it's in the public interest, and that it doesn't violate the regulatory principles. And there's also evidence in the testimony and support that to that effect. So we should be in compliance with the statute. Are there any questions about what I'm expecting to hear today and what I'm expecting to go through today? That was my introduction there. Miss Olson, anything? No questions from Miss Olson. She's waving her head back and forth, and that's the universal American response. No. Miss Stevens, anything?
No, Mr. Hearing examiner, thank you.
Mr. Black, any questions about what I've just introduced?
No, Your Honor.
Okay, Miss Souls, anything?
Yes, sir.
Okay, and thank you for all your other guys, your witnesses. Thank you for being there. Okay, at this point, let's do a mass swearing in, not of counsel, of course, but of any witnesses who may even testify. Let's just make it easy and swear them in. Ms. Gonsalves has agreed to swear in any witnesses. So Ms. Gonsalves, please swear them in. You may have your own procedure.
Okay, if you would please rise.
Any possible witnesses?
Thank you. Do you and each of you solemnly swear that you will testify truthfully today in the proceedings now occurring? So help you God.
Do.
Thank you.
Thank you. And Ms. Sauls, you are, of course, a pro se litigant as well as a witness in case you choose to testify. Okay, thank you all, and thank you, Ms. Gonzalez. Now we're going to move to some preliminary matters, and I want to put on the record. This is one of the things we discussed before we went on record, but I want to put on the record that there's an understanding of all parties through counsel that the filed direct testimony shall be admitted without further examination. In other words, everyone waives cross-examination. And we also discussed that I'd like to identify each of those direct testimony and label them as they are admitted into evidence, there being no objection. I'm going to once again go around. Is that a correct understanding of the parties, Ms. Olson?
Yes.
Ms. Stevens, is that correct?
Yes, sir.
Mr. Black
Yes.
and Ms. Sauls?
Yes, sir.
Now, once again, keep in mind, we're creating a record. There may be a transcribed record, and that's why I ask you, each of you to acknowledge, and it creates the record, which can be important in case a case, I think that's correct, ever would go on any kind of an appeal, and a judge who wasn't present today might be reviewing a transcript. Anyhow, try to think ahead. So the application herein included the testimony of Mr. Sheitzel and Mr. Gomez. Is that correct, Ms. Olson?
Mr. Hearing Examiner, the application included the direct testimony of James Schuster, the direct testimony of Manuel Gomez, and the direct testimony of Renee Gonzalez.
I'm sorry, I always forget him. There he is, right there. And the actual plan was attached to Mr. Gomez's and part of his testimony as an exhibit, correct? MG2?
That's correct.
All right. And the application was part of Mr. Schitzel's, and I apologize for the mispronunciation, his testimony. Is that correct?
That's not quite right. We typically just file an application. It's somewhat
Yeah, I
akin
know.
to meeting, and then the testimonies are filed in support of the application.
Yeah, I understand that, and I just wanted to bring that to light. It's always interesting for me because, in my opinion, the testimony is somewhat distinct from the application itself, even though they're filed simultaneously. In fact, in the same PDF filed with the commission. But in my opinion, when we have a hearing on a case, we still have to lay a foundation for the testimony, and therefore they get, in my opinion, pulled out of that filing. So I'm going to consider that the testimony of Mr. Can you say that name again, please?
Certainly, it's Schiestel.
Schiestel. I'm going to try to not ask you again, Mr. Schiestel. I just don't want to say it incorrectly, is my caution, Mr. Schiestel. I'm going to pull out his testimony, and Ms. Olson, I presume you have a motion to admit the testimony of Mr. Schiestel dated May 5th, 2021, which was pre-filed, correct?
That's correct. The pre-filed direct testimony of Mr. Schuster, EPE would move to admit that. into
Okay,
record.
you've moved to admit it. I may just move sua sponte just so that we don't have to have this uncomfortableness. Is there any objection to the admission for the record of the testimony, Mr. Schietzel, dated May 5th, 2021? No objection heard. It is admitted. I'm going to label this. Well, I'll ask you how you'd like to label it. I would put it as applicants 1. Is that any objection to that, Ms. Olson?
No, Your Honor, we usually label it as EPE1, but I have no.
Well, I'm not picky either, as long as we all know what it is. Now it's on the record. I'm labeling it as EPE1. It's admitted into the evidence. That's the direct testimony of Mr. Chisel of May 5th, 2001. Next, I'll do it sua sponte. I believe we all understand, just to make things move a little quicker. The direct testimony of Manuel Gomez, May 5th, moved into evidence. Any objection to the mission of the direct testimony of Mr. Gomez, which includes the actual 2021 New Mexico Renewable Energy Act procurement plan, at least the one which was proposed as Exhibit MG-2. Any objection? We'll go around the same way. Ms. Stevens, any objection?
No objection.
Thank you. I know there's an agreement. No objection, Mr. Black, is that correct?
That's correct. No objection.
And Ms. Souls, no objection?
No objection.
Okay, I'm going to label this as EPE Exhibit 2, and the direct testimony of Manuel Gomez is now part of the record, and it is evidence. Next, the same thing for Renee F. Gonzalez, dated May 5th. I sua sponte moved for introduction. There's an agreement that there will be no objection. Is there any objection, Ms. Stevens?
No objection.
And there's no objection, Mr. Black?
No objection.
No objection, Ms. Souls?
No objection.
EPE 3. Testimony of Gonzalez, EPE 3. Now part of the evidence. Thank you, Ms. Olson. Is there any other direct testimony other than the stipulation, in support of stipulation, which we'll get to, that you had planned to admit, such as the actual application?
Mr. Hearing Examiner, I have no problem if you want the application in the record. It's filed with the commission and we were not intending to admit it as a separate exhibit.
I do not have a problem with you not moving to admit it. I just wanted to cross that T when we got to it. Okay. Thank you. And then we'll move on if there's no objection. Since I kind of established a little procedural order, we'll go, and with respect to Mr. Black and to Ms. Sauls, we'll go to Ms. Stevens. Ms. Stevens, you presented the direct testimony of Mr. Provencio, and he's here, which is really nice. And you also presented the evidence of Ms. Laura Q. I probably pronounced that incorrectly, and I'm sure you'll correct me. Is that correct, those two direct testimonies?
Yes, the city offered Lisa LaRock, and we have already pre-numbered the testimonies. So I would ask that,
Okay.
that you order them, LaRock number 1 and Mr. Jose Provencio's direct testimonies number 2. That's the versions I sent out yesterday for the court reporter.
You like CLC number 1?
CLC 1 and CLC 2. It's already in the versions I emailed to everybody yesterday.
And last Wednesday, right?
And I would add to that, just for the record, that in Mr. Provencio's direct testimony, the exhibit that was previously numbered JFP 5, but was after JFP 1, is now correctly numbered JFP 2. And that was a point that Mr. Black noted during a prior chart last, I think, pre-hearing conference.
Well,
So
just,
the only change there is that the exhibit number within Mr. Provencio's direct testimony is now corrected from the version that was filed in August 11th.
Okay, so we go with the more recent one filed. There's no need for him to testify as to that change, correct, Ms. Stevens?
Correct. I think that everybody understood that that was being made. I did not redline it. It seemed silly and messy.
Thank you. And as you understand my position, we're making a record. We're making it as clear as possible. And I appreciate you explaining that for the record. That being said, we'll move. I presume you moved to introduce these two pieces of evidence. Is that correct?
I do, if you'd like me to make the motion. And the city moves, and I'm Anastasia Stevens on behalf of the city of Las Cruces. The city moves to admit CLC exhibit number 1, the direct testimony of Lisa LaRock, filed in this case on August 11, 2021. And
Any-
also
Continue.
CLC Exhibit Number 2, the direct testimony of Jose F. Provencio, filed on August 11th, 2021, with a correction to the exhibit number.
Thank you, Ms. Stevens, and I apologize. I didn't have counsel identify themselves at the beginning of the hearing. That's something I usually do. You know why? It's not on my crib sheet. You know, things become so normal, you don't write them on your crib sheet, and then you forget to do them. But Ms. Stevens does represent the city of Las Cruces, as she said, and if other council could introduce themselves, I'd appreciate that when they're addressed. So that brings us to Ms. Olson. Ms. Olson, who do you represent, of course?
Hearing examiner Carrie Olson from Montgomery and Andrews on behalf of El Paso Electric Company.
Of course, and we all know that, and you're stating that for the record, of course. Do you have any objection to the introduction of CLC number 1, which is the testimony of Lisa LaRocque, or CLC number 2, which is the direct testimony pre-filed of Jose F. Provencio?
The company has no objection.
Mr. Black, does staff have any objections?
No objections, Your Honor.
And last but certainly not least, Ms. Souls, any objection?
No objection.
There being no objection, direct testimony of Ms. Lisa LaRocque, labeled CLC number 1, is admitted and is now evidence in the case. The direct testimony pre-filed of Jose F. Provencio, dated August 11, 2021, and labeled CLC number 2 is now evidence in the case. And I can consider it now that it is evidence. Thank you, Ms. Stevens. And now I'd like to just move to, not just, but we'll move to Mr. Black. And thank you for being here, Mr. Black. Would you identify yourself for the record?
My name is David Diog, D-A-Y-O-G Black. I am counsel for the utility division staff who are employees of the New Mexico Public Regulation Commission.
And pre-filed testimony included Charles J. Martinez of August 11 and Milo Chavez of August 11th. Was there any other pre-filed testimony?
I just have, there was no, Your Honor, there was no additional pre-filed testimony. There was, however, an errata that was filed.
And you want to admit the errata as well, is that correct?
That's correct. It's staff's errata to the direct testimony of Milo J. Chavez, which was filed August 11, 2021.
Okay. Let's label, do you have any problem with labeling the testimony of Mr. Martinez as staff's number 1?
No, Your Honor.
Done. Staff's 1. The direct testimony of Mr. Chavez, I'm going to label it as staff number 2.
That's correct, Your Honor. Staff agrees.
Thank you. And I'm going to label the errata as staff number 3. Any objection? Any problem with that, Mr. Black?
No problem, Your Honor.
Okay, so do you move for introduction of these 3 exhibits?
So moved.
Thank you. Tell you what we'll do. How about we'll wake up Ms. Souls and ask her, do you have any objection to the introduction of staff exhibit 1, 2, or 3?
I have no objection.
Ms. Olson, any objection?
No objection, Your Honor.
Ms. Stephen, any objection?
No objection, Your Honor.
There being no objection from any of the parties, staff exhibits number 1, 2, and 3 are thereby admitted. They are now part of the record. They are now evidence, not only filed, but evidence, and I can consider them in the case as evidence, as can the commission, of course, the commissioners, if you will. All right. I have the unopposed comprehensive stipulation in my hand. Is there any opinion on, that's going to come in? It's attached to the testimony of Mr. Schiesel. Is there any party that wishes to? It's joint, of course. At least I see it as joint, as unopposed. and it's signed by all the parties, signatories. Does any one party seek to move for admission of the unopposed comprehensive stipulation as an exhibit? So no one party does. So all of the parties jointly move for admission of the stipulation as an exhibit. And now Mr. Black is nodding. Have the parties reached an agreement that the stipulation would be admitted as an exhibit?
Mr. Hearing Examiner, I don't know that it's necessary to have it in the record in duplicate copies. I think all of the parties to the stipulation had contemplated that it would be an exhibit to Mr. Schichtel's testimony in support of the stipulation. And I think from our perspective, that's sufficient, but I defer to whatever your practice and preference.
Well, it actually is. It's Exhibit JS-ST1, page 1 of 17, the way I see it. And it is part of the evidence. So if Mr. Black is the one who nodded that he wanted to move for admission of it separately, or that he wanted it to be moved jointly. Mr. Black, are you satisfied that the Exhibit JS-ST1, which is attached to Mr. Schichtel's testimony of September 4th, that's the unimposed, in support of the unimposed comprehensive stipulation, is in fact the unopposed comprehensive stipulation, and that's the one we'll be referring to for approval of the stipulation, which is, why we're here today.
Thanks for the question, Mr. Hearing Examiner. I was unclear as to whether or not the testimony in support of stipulations were actually entered into the record as evidence as of yet.
Well, they're not as of yet, but they're going to be momentarily unless we, spend more time on the unimposed comprehensive stipulation. Don't worry, we can sweep up after we're finished labeling stuff and admitting evidence just to make sure we don't forget anything. So with that being said, can we move on to the introduction of the testimony in support of the comprehensive stipulation? Any problem with me going forward with that? Thank you, Mr. Black. And Ms. Stevens, any problem? Ms. Olson and Ms. Bowles, we're going to go forward.
Mr. Hearing Examiner,
Yes, ma'am.
forgive me, I do have a question about how this is all working together. Since the stipulation refers to the application, don't they both need to be in the record?
Well, the application was filed with the commission. It's like the initial pleading. The question is whether it has to be evidence. And in some hearings, the parties choose to admit the application. In other hearings, it's not done. I believe that I can refer to the official pleadings in the record, and I believe the commission consider the pleadings. That's the nature of a pleading. A pleading, however, is typically what lawyers call averments, A-V-E-R-M-E-N-T, averments of counsel rather than sworn testimony, if you will. And sworn testimony is evidence. Averments of counsel is not evidence. And frankly, not to get too confusing, but that's why I was concerned about the separation of the direct testimony from the rest of the application, and the admission of the direct testimony as evidence, and the rest of the application, which was submitted simultaneously, because that consists more of averments of counsel, not more, but it consists of averments of counsel as any other pleading does. Now, I might be making you more confused, but this is the way I see things. There is a distinction between averments of counsel and testimony. Averments of counsel is not evidence. Testimony of witnesses is evidence. Make sense?
Very well. As you know, I am not an attorney, but I am aware that the stipulation refers directly to the application. Thank you for the clarification.
Yeah, well, it's something that I have. It's like a shell game where I have to keep an eye on, and especially when we have pro se litigants like yourself. I've even literally told them to change hats for me. Now put on your witness hat. You're a sworn witness under oath now. Now take off your witness hat and put on your counsel hat. Now you're a lawyer for Miss Souls, who just testified with their witness hat on. So there's a distinction. And when there's a filing like there was the initial application, it included testimony as well as the application itself. And in my eyes, they're distinct. Now, that doesn't mean, I can't look at the application because it was a filing, but I will look at it as in a slightly different light than I would look at testimony of a witness subject to cross-examination, which is by its very nature more reliable. Okay, I may have given you more of an answer than you wanted. So let's get back. Is that okay, Ms. Souls?
Very well. You're running
Okay.
this. Thank you.
And my question was, did you have any objection to the introduction of the testimony of Mr. Sheetzel in support of the unopposed comprehensive stipulation dated September 14, 2021? And your answer is?
I have no objection.
Okay, and none of the other parties had any objection to introduction of this exhibit, correct?
No objection.
Okay, so let's label this one, because this is EPE, and EPE was already up to what? 3 or 2? They were up to 2.
3.
Up to 3, so this will be EPE number 4. Is that correct?
Yes.
EPE number 4, there being no objection, EPE number 4 is admitted into evidence. It's now part of the record. Thank you. And thank you for understanding my procedural niceties in intending to be thorough and clear and create a clear record. Okay, the next is, hold on just a second. Did EPA have any other evidence in support of the stipulation, Ms. Olson?
No, Mr. Hearing Examiner, our evidence is confined to the testimony that we've provided.
Thank you, that's fine. Once again, I just wanted to make sure I wasn't missing anything, and then there was nothing further. Okay, then let's move on to staff. And Mr. Black, I believe you submitted the testimony of Mr. Charles Martinez, and thank you for being here, Mr. Martinez. Let me see if I had any questions. Let me go back 1 second and look at Mr. Sheetzel's testimony. I think I had a question or a couple questions, and I might, from the bench, reopen for a question. I look for ambiguities and want to clarify ambiguities. And I do have a few questions. So I'm going to sua sponte from the bench reopen the admission of an EPE4 and ask a few questions if that's okay. Mr. Sheetzel, you're still under oath. You understand that, correct?
Yes, sir.
Okay, I just wanted to, you're going to see how picky I am. But I saw an ambiguity on page 3, your first paragraph, where there's in the first part of that sentence, you refer to all the parties, the stipulating parties, and you identify all the parties, stipulating parties. I don't have a problem with that. But in the next the very last phrase of that sentence, you seem to indicate that there are two groups of parties, the stipulation party and EPE on the other side. There aren't two groups of parties, are there? In other words, I seem to be missing the word "the" before stipulating parties, and instead of the word "and" in that sentence, and EPE, it should be including EPE at the end of that sentence.
I think that would be fine, or you could just strike the and EPE, either one.
And well, if as long as you've just stated under oath that it will be fine, so consider it done. To me, it sounded like there was possibly not unity among all the stipulating parties, and it looked as it could possibly be misread as EPE and the stipulating parties, as in on the other side of a table, if you will.
Understood.
Okay, thank you for that. You noted the correction further on in that page. Let me see if I had anything else. Yeah, there was a new revised rate attached to the STIP, of course. And the way I read all the testimony, it seemed to include the change, which is the non-inclusion of certain charges as agreed in the rest of the stipulation, which adjusted the monthly rate to a lower rate than was requested in the plan. Are you following me so far?
Yes, sir.
Okay, but I'm looking on page 7, and you use in the paragraph from the top of page 7, second line from the bottom, you state that you will revise the proposed revised rate. And then in the same document, it appears to me that you actually attached the rate as revised. In other words, you have already done it, not that you will do it. Am I reading too much into that, or am I confused? Could you clarify that, please?
Mr. Andrew Examiner, I think the reference there is following an order approving the stipulation, we would file an advice notice that included the approved tariff and rate.
And it's the same one which is attached to the stipulation, which is attached to your testimony, right?
Correct. Assuming there were no changes in the order, then yes.
Gotcha. The word "will" kind of threw me. I was seeing it already extent, and well, and then I saw the word "will." And like I say, I'm just trying to clarify anything that could be interpreted as any type of ambiguity. Let me look a little further and see if I wrote anything else. Yeah, about the mirrored carrying charges, which I like to call interest. It's just a more common word for me, but carrying charges is fine. I'm looking at page 9, and I'm looking at the final sentence in your first paragraph. And I understand that the carrying charges could be paid to the rate holders, but I'm not clear whether the inverse, if you will, if there's going to be a payment to CRLEF, whether the carrying charges will also be paid to CRLEF. Could you clarify that?
Yes, Mr. Andrew Examiner. Yeah, I do agree that's unclear. I believe what we agreed to was that if the dollars or if the money that has been recovered from ratepayers and customers to date ended up being returned back to customers following a Supreme Court order, that would include interest from the carrying charges, which would begin, we'd start applying first of next year. If instead the order from the Supreme Court is that those monies should be paid to CRLEF, we would not include the interest or charge customers for that interest. We would just pay to CRLEF under the contract the rec payments for what has been supplied so far, and then of course the payment going forward.
Yeah, I got that, but the question was whether the interest that you had collected for the contingency that it would be paid to the ratepayers would then be paid to CRLEF because you were basically holding their money for that time period. That's what I wasn't clear about.
Right, and the parties, I believe, agreed that if the money goes to the balance goes to CRLEF, it would not include interest.
And of course, you're conceding that would be subject to the commission's a commission's order regarding that matter, correct?
Certainly.
Of course, thank you. All right, I saw a little ambiguity there, and I just wanted to get some testimony to clarify that ambiguity. Let me see something here. Okay, I didn't have any other examination, but because I briefly examined this witness, as the other parties have a right to also examine, so I'll start with Miss Olson. Should there be any rehabilitation, do you care to examine within the scope of my examination?
Mr. Hearing Examiner, I don't have any further examination for this witness, but I just wanted to clarify one thing for the record. You referenced the proposed form of tariff and advice notice that was attached to the stipulation. I just want to be clear that that is not a signed, submitted advice notice. It's merely intended to provide the form that the parties would contemplate would be filed, assuming the stipulation is approved. And so we would subsequently file an actual advice notice with an advice notice number that's consistent with the commission's approval of the rate.
Okay, well, let me ask you questions. Isn't it actually to document the agreed stipulated rate of 0.008516, which was a compromise rate agreed by the parties?
I apologize, is that directed to me or to Mr. Schiestel?
Well, you were just speaking, so I'm going to ask you, and you might want to examine your witness concerning that.
Sure. So is your question, is the proposed form of a tariff that's attached to the stipulation reflect the revised rate with the SIRLIF removed?
Yeah, I'll ask that of your witness. Sir, could you respond to that?
Yes, it does.
Okay, thank you. And is that why it was attached to the stipulation?
Yes.
Thank you, sir. And when you said the word will in your testimony, you understood my questioning about why would you have to do it if you've already done it and it's attached to the stipulation, right? And you already explained that.
Yes.
Okay, thank you. And Miss Olson, do you have any other questions for this witness in perhaps rehabilitation or redirect?
No, I do not.
Thank you. Miss Stevens, any questions?
No questions, thank you.
Miss Black, within the scope of my examination, any questions?
No, Your Honor.
Miss Souls, any direct or any, excuse me, any
Sir,
questions?
I do have one question.
It should be within the scope of the things I just asked him.
Of course.
So what is it? Ask me the
Mr.
question.
Schiestel, So when the hearing examiner was asking you about the carrying charges regarding the payments for Rex to CRLEF, would you agree with me that we, the stipulating parties in the negotiation, did not address that the only thing the stipulation addresses is the carrying charges as described in your testimony? Would you agree with that?
I mean, if I understand your question, certainly the stipulation itself only contemplates the payment of carrying charges to customers if those dollars return to customers.
And would you then also agree that anything else was simply not part of what we, the stipulating parties, agreed to? And
Yes.
thank you. That's all.
Thank you. And since Ms. Souls asked a question, would any other counsel like to examine this witness related to that even more narrowed question? Ms. Black, anything?
No, Your Honor.
And Mr. Black, Ms. Stevens, any question?
No questions, Your Honor.
And Ms. Olson, any question for your witness?
No question.
Thank you. There being no further questions, I've already admitted it, and lest there be any misunderstanding, EPE number 1, direct testimony, Mr. Sheasel is admitted. It already has been admitted. Okay, so with that, I'm going to move over to the testimony. Oh, that was EPE 4 in support of the comprehensive stipulation. Pardon me. It has already been admitted. Sorry for my confusion. Oh my. Ms. Gonzalez, how are you doing there?
Just fine. Thank you for asking.
Are you noting all my confusions?
Exactly.
Thank you. That's your job. Okay. That being said, we will move on, I believe, to the testimony in support of uncontested comprehensive stipulation filed by staff by Mr. Black. Mr. Black, you filed testimony of Mr. Martinez of September 14th and Mr. Chavez of September 14th, correct?
That's correct.
How would you like to label these?
Your Honor, I think since we're up to the next number is 4, Staff Exhibit 4 would be the direct testimony of Charles J. Martinez. Excuse me, wrong. The Staff Exhibit 4 would be the testimony of Charles J. Martinez in support of uncontested comprehensive stipulation.
Thank you. And you would label as staff's number 5, the testimony in support of uncontested comprehensive stipulation of Mr. Milo J. Chavez, correct?
Correct.
Ms. Gonzalez, I'll try to speak a little slower. It's a problem. You need not, you use your professional judgment on whether to record my comments to you. So that will be staff's number 5, Mr. Chavez's testimony in support of. So we all know, do you move for admission of these?
So
Mr.
moved.
Black? So moved.
Yes.
Any objection? None, Ms. Stevens?
Objection.
Ms. Olson, no objection?
No objection.
Ms. Souls, no. Any objection?
No objection.
Okay. Let me make sure I didn't have any ambiguities to clarify. No, I don't believe I need any testimony. There being no objection, and staff's exhibit number 4, the testimony of Charles J. Martinez in support of uncontested comprehensive stipulation, dated September 14th, is thereby admitted into evidence and is now part of the record and is evidence to be considered as to the standard of, as to whether the stipulation is fair, just, reasonable, and in the public interest. Same goes for staff's exhibit number 5, the testimony in support of uncontested comprehensive stipulation of Mr. Milo J. Chavez, dated September 14, 2021, is thereby admitted and is now part of the record and can be considered as evidence. Okay, Miss Sauls is always last, so we won't make her last this time. Miss Sauls, I have in
Yes,
my
sir.
hand, you're very concise, and I appreciate conciseness. Testimony of Mary Lee Sauls in support of the unopposed comprehensive stipulation. Your testimony is dated September 14th, 2021. You very clearly support approval of the comprehensive stipulation. You very clearly answer the questions which I have about the stipulation, and I appreciate that. Do you have anything you would like to add to your testimony? You are a sworn witness under oath right now.
Yes, sir, I understand that. And no, I stand by my testimony.
Okay. Since I just asked Ms. Sauls a question, even though it was more of a procedural question, do I presume correctly that none of the other council have any questions of Ms. Sauls?
No questions, Your Honor.
Ms. Stevens, no
questions.
questions? And Ms. Olson, no question. Ms. Olson, you don't have any questions of Ms. Sauls? Is that
I
correct?
apologize.
No problem. And she's nodding her head left to right, indicating no. So there being no questions, Ms. Sauls, this would be your exhibit number 1. I don't have direct testimony from you. Is that correct?
That is correct.
So this is, I'm going to label it MLS, meaning Mary Lee Sauls, number 1, with your permission, and you've just nodded in agreement. I have no further questions. Are there any objections? Thank
No
you.
no objections, Your Honor.
Ms. Stevens, no objection?
No objections.
No objection, Ms. Olson?
No objection.
Thank you, and thank you for allowing us to keep the record clear. I appreciate that. There being no objections, the testimony of Ms. Sauls, labeled MLS number 1, is admitted and will be considered on the question of whether to certify and recommend approval of the stipulation. We move on now to the city of Las Cruces. Last but not least this time, and I want to thank Ms. Stevens and thank Mr. Provencio and for the testimony in support of the unopposed comprehensive stipulation, which we're now going to label move for admission and likely admit. It was well written and easy to understand. So I appreciate that, and it was very thorough. So let's move on to Ms. Stevens. Do you move for admission of testimony of Mr. Provencio?
The city moves for the for admission of CLC Exhibit number 3, the testimony of Jose F. Provencio on behalf of the city of Las Cruces in support of unopposed comprehensive stipulation filed on September 14th, 2021.
Thank you. Any objection, Mr. Black?
No objection.
Ms. Olson, any objection?
No objection.
Ms. Sauls, any objection?
No objection.
Our record is very clear. I have no substantive questions that I think I need to ask. And there being no objection, the exhibit labeled CLC number 3, which is the testimony of Jose Provencio on behalf of the city of Las Cruces in support of the unopposed comprehensive stipulation, is thereby admitted. It is now part of the record, it is now evidence, and I can and will consider it regarding the unopposed comprehensive stipulation. Let me look at my crib sheet and see if I've forgotten anything here. Like I said, the regulation indicates that there shall be legal argument. So just to cross that T, I'd like to hear some really brief legal argument. And I wouldn't mind hearing some argument about the deferral within the stipulation of certain issues. And, this is an annual filing type of case. This could have been approved by the commission, or it would even have been automatically approved, had there, been no objections. So that's the nature of this case. And the reason I say that is because the deferred contentions, if you will, which were settled by stipulation, involve previous cases and involve subsequent conditions of extent cases, not just this case which we have before me today. And so that's the only thing I might want to hear some legal argument about why this case should have an order approving a stipulation which incorporates agreements of the parties relating to previous cases and cases which haven't even been decided because they're still pending, such as before the Supreme Court and that other 2019 case. So I wouldn't mind hearing a little bit about that. And that's a suggestion, if you care to, about the nature of those deferred arguments and why it's legally okay, if you will, to include them in the stipulation, which would become approved if I recommend it. So you might want to comment a little bit upon the perhaps even the scope or the gravitas of the 4 peaks, which is only 2 to 4 megawatts, is the way I read the testimony. In the whole scheme of things, that's small relative to the other sources of renewable energy. And you might also comment about the significance or lack thereof of the other issue, which is the distributed generation deferred issue, which is also not that it's not significant, but the relative significance of that deferred issue, which might give some comfort to me when I recommend when I do the certification, presumptively recommending approval of the stipulation. So if council would care to address those 2 issues, I might appreciate it. Now, the person that goes first doesn't have much time to prepare. But since Ms. Olson represents the applicant, I'm going to ask her just to make a very brief closing argument so we can say that we've complied with the legal argument requirement of the regulation. Ms. Olson, please do a closing argument.
Thank you, Your Honor. In summary, I think the case law defining the policy supporting stipulations is pretty clear. The commission has a longstanding policy of supporting resolution of contested cases through stipulation. It avoids unnecessary costs of litigation and oftentimes gets to a better result because it has the benefit of input from all interests. The commission's authority to consider and approve a stipulation is provided under the commission's procedural rules in 1.2.2.20. The standard used by the commission to approve a stipulation is that it must be fair, just, reasonable, and in the public interest. The additional criterion used by the PRC to evaluate stipulations are the stipulation is reflected, or the settlement reflected in the stipulation is a product of serious bargaining among capable, knowledgeable parties. The settlement as a package benefits ratepayers and is in the public interest, and the settlement does not violate any important regulatory principle or practice. I think the stipulation itself, supported by the testimony of the supporting witnesses, elaborates on these elements and establishes by a preponderance of evidence that each one is met. The stipulating parties include representatives of public, governmental, and consumer interests. The parties are in agreement that the stipulation that the conditions in the stipulation, that the 2021 as modified by the conditions of the stipulation satisfy the requirements of the Renewable Energy Act and Commission Rule 572. They excuse me. For this plan year, and demonstrate how EPE will be in compliance with the 20% RPS through 2024. And I think it's important to remember that the scope of this plan is just for the 2022 plan year. So we don't need to get ahead of ourselves to look at anything beyond that. So I think the testimony and evidence establishes that it's a fair, reasonable, and just resolution to this case and benefits the public. Specifically in reference to the CRLEF agreements that you referenced, you know, to be honest, we have no control over the New Mexico Supreme Court's docket. We unfortunately can't control how quickly a resolution is made on that issue, and the delay has caused difficulties in planning. We don't know what's going to happen. Neither EPE nor the city can read the tea leaves to figure out how the commission's going to rule. And so I think we've, through the past couple of years in these cases, has come to a clear understanding that either the customers or CRLEF will ultimately get the money for those REC payments. The difficult question is what to do in the interim. And we've had lengthy back and forth negotiations over several years between the city, EPE, with staff, and Ms. Souls weighing in. And I think that the resolution that we've come to in this case to provide interest and to stop collecting the CRLEF payments from customers in order to not further increase the balance is a fair resolution, at least for the course of this plan. And we, I think, are all collectively hoping that we have resolution from the Supreme Court before we have to address this issue again next year. I think if you look back at the analysis of the hearing examiner and the certification of stipulation as accepted by the commission last year, he looked at whether it's more beneficial to collect the money now and ultimately return it, and made a finding on that. However, as that balance continues to increase, it adds complexity to that issue. And so I just reiterate that I think the bargain for agreement after serious negotiations over the course of years is a very fair result to get us through this next plan year and hopefully to have direction from the Supreme Court before we have to file our plan next year. And then I believe the other deferred issues, the large customer adjustment, that is again a complicated issue. And I think everybody finally came to the agreement that that those customers need to be aware of potential consequences and have the ability to have notice and opportunity to present their position on it. And so deferring that to next year when they can be afforded notice of that is a fair result to those customers. And the remaining deferred issues have to do with the commission's pending rulemakings. And I think it's a fair, just and reasonable result to defer making a definitive determination on how to move forward with DG rec counting or complicated changes to the rate rider when those are currently pending before the commission in ongoing rulemaking.
Thank you, Ms. Olson. Is there anything else?
I believe that's
Okay.
it. In summary, the uncontested stipulation satisfies the commission standard for approval, and we ask that EPE's application 2021 plan and 2021 cost rider as modified by the terms of the stipulation be approved.
Thank you, Ms. Olson. I learned as a lawyer too to always ask for what you want. So that's really important. I want to thank you for that closing legal argument in compliance with the regulation. I want to give other counsel just a little more time to prepare by letting me say a few words in response and in comment. Of course, what I say is not evidence. What you said, Ms. Olson, is not evidence. But the NMAC Reg 1.2.2.20A3 states that stipulation settles substantive issues. And I've always thought personally this agree to disagree is a pretty dumb statement. And agree to defer is a few notches from agree to disagree. And the question that arose in my mind is whether an agree to defer actually is a stipulation which settles the substantive issues. The question is it settled by deferring or not? I'm going to have to decide that. And that's why I wanted to hear a little legal argument upon the deferred issues. I noticed that the large customer adjustment clause that you guys deferred, and the reason, if I understand correctly, is because those large customers weren't even at the table, frankly, and they should be entitled to notice and to have a say in stuff that affects those large customers. That's the way I read the testimony. That certainly seems like a pretty good reason to defer, and I take that very well. Ms. Olson, you said complexity of that issue a couple times, and I believe this case is complex in many ways, and that also favors a resolution by the parties conferring with each other and by stipulation rather than by litigation, which is always dangerous. And the more complex the case, the more dangerous it is for parties. So I agree that actually, I'm a mediator, so I by nature favor alternative dispute resolution if possible. But for each case, especially in this type of case where I have to decide whether to recommend a stipulation, in a case that has complexity of issues, it actually favors resolution by stipulation. So I just want to comment upon that. When I was referring to the before and the after thing as related to deferrals, what I meant was that, there's these two plants that haven't opened up yet, and there's two parts to the two plants. Anyhow, that's been deferred. Their COD, their operations are at the end of 2023. But there's anticipation that there's going to be enough excess RECs to cover the 2020 and 2021 deficit. And that's the kind of stuff that struck me as unusual, that we're promising to comply with substantial compliance, understand the previous cases and understand the the substantial compliance argument, and it's been recognized by the commission previously, that promising something that hasn't even happened yet in payment of something which is perhaps substantial compliance, an interesting concept in its own right, is another reason there's been a deferral. And I just wanted to hear a little bit about that, perhaps more appropriate in legal argument, because the witnesses have already said what the witnesses are going to say. So that being said, Ms. Olson, I'll give you another bite at that apple if you choose, because all the other counts are going to have a bite at it. Ms. Olson, do you have any further comment? Legal
Sure, I
argument?
think, yeah, your comments and observations are well taken, and a lot of this goes back to the significant change in the statute in 2019, and the change in RCT calculation, and this is lengthily laid out by Mr. Schussel in the plan filing last year, but prior to that major change in statute, EPE was somewhat inhibited by the RCT, and now the company is working towards obtaining renewable procurements. However, as again laid out elaborately in that testimony, you can't just snap your fingers and bring on a renewable plant. And so unfortunately, the competitive procurement provisions of the statute require a lengthy process. And so it wasn't possible for EPE to identify a plant to bring on in 2022. And so the renewable resources that were approved last year are intended to bring us into compliance through 2024. We do have to wait for them to come on. And then I reiterate again that this case is only about approval for 2022. So when you're talking about deferring issues, that isn't really deferring substantive issues in this case. The substantive issue in this case is EPE's plans sufficient to substantially comply with 2020 RPS in this case? We don't have to decide whether or not the commission should be counting DG recs, because there isn't an alternative on the table. I think as EPE presented in its direct case, there are no alternative resources available other than the Macho Springs procurement that we brought last year and was heavily opposed. And so it's a moving forward process. And so all the commission has to look at this year is EPE's has EPE set forth a plan for compliance in this plan year? And the answer to that is yes, as agreed to by all parties. Those issues of what's going to happen in the future can be addressed in next year's plan filing when we look at, do we have the resources sufficient for the following year? I hope that sheds a little bit more light on the questions that you have.
It does. You ever heard those questions? Have you stopped beating your wife questions? That's a lawyer type question, but I'm going to ask you one of those. Did I hear you just say that the deferred issues are not substantive issues?
Well, I mean, what is a substantive and substantive to what? And so I would argue that they're not substantive to deciding whether or not EPE has presented a plan for compliance in the 2022 plan year that satisfies the statute and the rule. They are substantive issues that need to be resolved or that will help give parties guidance. And we're hoping that we get that guidance through the Supreme Court and the Commission rules. We don't want to waste a bunch of resources, including ratepayer resources, hashing out these issues in a proceeding like this between very few parties when there's ongoing rulemakings involving all interested parties and all interested stakeholders in which we can come up with a reasonable solution to these that can be applied in the cases. And so are they substantive? Sure. Are they relevant and necessary to decide for this plan to be approved? I would say no.
Just one more question. I think this will be the last question. Are you saying that the commission could have approved the plan without addressing the deferred issues, but the deferred issues are included in the stipulation because those issues were raised by those in opposition to approval? Is that correct statement?
That's right. And I think Ms. Stevens can elaborate on that. But I think our case in chief started from where we left off in the commission's order last year, which identified several rulemakings.
Okay. Thank you, Ms. Olson. Who wants to go next? Ms. Stevens, would you like to provide some legal argument in compliance with the regulation?
Yes, Mr. Hearing Examiner, I will, and I'm sure I won't be as articulate as Ms. Olson. I appreciate what she said and agreed with almost everything, probably everything, it's a slightly different slant. I think that what you're getting at, and certainly where the city was coming from in terms of being interested in fact, eager to settle this case, was because the company came forward with an application that does not propose new renewable additions. It's an annual process, and this ended up being sort of an interim annual process because there's really nothing new out there to fight. As Ms. Olson said, we can't, well, certainly the interveners can't snap our fingers and make the company go out and procure additional renewables. And so we had to take the case as it was filed. And our intent with the elaborating on the deferred issues was to make sure that they stay deferred and don't get approved or resolved by lack of a ruling in this case. And I mean, it's hard when it's a stipulated case because are you just approving the stipulation or are you approving everything? When we talk about the application, which you didn't admit into the record, are we approving by accepting the plan that's the annual plan that's attached to Mr. Gomez's direct testimony? Mr. Gomez isn't here to testify. We do not want we want it to be clear that by approving the stipulation, indeed last year's stipulation, which explicitly dealt with the same issue on the DG Rex and the large customer cap, that by explicitly deferring those issues, you're not implicitly resolving them in favor of what the company filed in its original application and all the pro-company implications that could possibly be drawn from that application. So it's really important to us that the deferrals be explicit. In the case of the DG Rex, the commission, the city was the one party opposing last year's stipulation, and we briefed that extensively, and the hearing examiner chose to defer it to the rulemaking. As of now, that rulemaking is still pending, and that particular issue has not been explicitly rolled into that rulemaking for discussion by the commission. It would benefit all of us, I think, to have your order in this case note that it's been deferred, but is it going to be decided at some point? Because that one, you mentioned that is not a small REC amount, but it's not huge. It is a considerable REC amount, and we need clarity going forward. Everybody needs clarity going forward, but the clarity should be consistent with PNM and SPS. It would be crazy to have 3 different versions of the amended Renewable Energy Act floating around out there. That would be illegal, wrong, just incorrect. So we don't want to go that way. So that's the big one. And and the large customer issue, my understาง, our understanding of the certification of stipulation in case 19000999 UT last year was that it should be addressed in this case. The company made a compelling argument that the parties should be involved. Again, we're explicitly not deferring that, we're explicitly deferring it so it doesn't just disappear into the ether, because if that were the case, those all but 4 or 5 of EP's customers would be paying more than $1 million extra over 2 years for something that they probably, in our opinion, shouldn't be, and certainly arguably should not have been held responsible for. So that's a lot of, if it's a $16 million a year plan, you can say that's not a lot of money, but it is, it starts to add up. And this, for the same reasons that the company agreed to stop collecting the CRLEF amounts, which were coming in at $500,000 to $600,000 a year. Maybe once that doesn't look like a whole lot, but when you get to 2 or 3 years piled up, it starts to become a sizable amount of money to ratepayers. With the CRLEF, I will throw a little bit off the record stuff here, but I'm the chair of the appellate practice section of the State Bar. We had our annual CLE a couple of weeks ago. At that CLE, Justice Bacon gave the report on the status of their ready list at the Supreme Court. And she mentioned that there was one PRC case on the ready list, meaning it's been briefed, argued, ready to come to decision. And I said, I'm jumping up and down in my seat. Oh, it's my CRLEF case. And then I spoke to Miss Olson, and she said, oh no, it's not, because our firm has a telecom case. And then I spoke to Mr. Herman on behalf of Doña Ana County. He said, oh no, it's not. I have a transportation case. So somebody is going to get, according to the Chief Justice, somebody is going to get a Supreme Court decision in a PRC case within the next 3 months or so, but we don't know which one of us it's going to be.
Now you guys know we do other types of cases here at the PRC.
So no, it was just funny because I was like so excited, and then Miss Olson said, "Oh no, that can't be," and we've got one that's sitting there. And then a few days later, Mr. So anyway, and you probably know that there are even more. I don't know how the court doesn't feel that way, but so we see the potential for that amount building, and again, if we keep it within a reasonable range, whichever way it goes up or down, the net effect on customers will be moderated. I can't say it, moderated, I guess is the word. If that were to keep growing, if God forbid, if the court takes another 2 years and that gets up to like a $2.5 million amount, that gets to be a sizable chunk of this rider each year. And then we end up with having to decide issues about how long do you make the refund period for? There are complications. So that's the CRLEF issue. The large customers, again, we agreed with the company that notice would be appropriate. That is not a number, mind you, that's not a number that is increasing. There are just 2 years at issue for that. 2019, the year in which the statute changed, in 2020, because as of 2021 and the stipulation last year, that those customers are no longer getting the special treatment, those 4 or 5 customers.
Thank you.
And the DG Rex, lastly, and just in reiteration, that is a big question that's been, if you go back and look at the briefs from last year's case, that's been floating around with the commission for a decade and a half already now, I guess. Going back to a 2005 docket, I believe it was. So it needs to be resolved by the commission in a case that everybody has their say, whether rulemaking or an inquiry specific to that is the best choice, because it is a legal question, to be honest. But it should not be just decided either by agreement amongst those of us, the five of us, four or five parties in this room, or through litigation amongst the 4 or 5 parties in this room when it has implications for P&M and SPS as well. And I don't think, maybe even the co-ops, I'm not certain. I have to admit that I never think in terms of the co-ops anymore. And other than that, I think, we were also careful in the stipulation to point out that the carrying charges was deferred in the rulemaking, but we decided in this case to bypass that. But again, that's something that we wanted to be express about. We thought that was in the public interest. It's not, at the customer deposit rate, it's not a lot of money, but it's a gesture towards what we think is fairness. And with that, I'll shut up.
Thank you, Ms. Stevens. That was comprehensive. I just wanted to, before I hear from Mr. Black and Ms. Souls, my concern is whether I recommend the stipulation and we're not having a hearing on the merits of the approval of the plan. We're not having a hearing on the merits because there's a stipulation. There need not be a hearing on the stipulation if the stipulation settles all the substantive issues. And my question was whether a deferral settles all the substantive issues. And I hear a couple of ways of looking at it, that the deferred issues are not actually substantive issues, that frankly, that they were not part and parcel of the application per se, and further that the deferral is more an express statement that those issues are the issues in other proceedings, the Supreme Court case and the new regs case. So they need not be resolved in this stipulation, and not resolving them, deferring them instead, does not qualify as non-settlement of substantive issues. In other words, the substantive issues in this case are resolved even with the deferrals. That was my concern. Anyhow, Mr. Black, are you ready to say a few words?
I am, Your Honor. Thank you.
Thank you.
Mr. Hearing Examiner, is staff's position that the terms of the stipulation settle the substantive issues in this case, that the terms of the stipulation are fair, just, and reasonable, and that the terms of the stipulation are in the public interest. And finally, that the terms of the stipulation satisfy the requirements of Rule 572 and the Renewable Energy Act. As to the deferred issues, staff provides its positions on 2 specified deferred issues in Staff Exhibit 5 at pages 2 to 3. Staff believes that the deferral of these 2 issues is fair, just, and reasonable, in the public interest, do not violate the requirements of Rule 572 or the requirements of the Renewable Energy Act, and in addition, serve the interest of administrative efficiency. Staff urges the hearing examiner to certify the settlement stipulation in a certification of stipulation, and staff waives the filing of exceptions to that certification of stipulation.
Thank you, Mr. Black. You'll find it interesting that one of my notes to myself is to request for something, presuming there's a recommendation of certification of the stipulation's approval, that you guys waive exceptions. Now, Ms. Souls, you've had the opportunity to hear everyone else's legal argument, and we know you're not an, thank you, Mr. Black. We know you're not an attorney, but I think you're pretty sophisticated. So I'm going to ask you, put on your lawyer hat, take off your witness hat, and in compliance with the regulation, to make a little bit of legal argument. So what you would be telling me is what the evidence has proven, and that there is sufficient evidence to prove what is necessary to provide for the commission to provide the relief you request.
Yes, sir. Thank you for that. I would note at the outset that for a renewable portfolio standard filing, an application for a Renewable Energy Act plan, that this case is unusual to me because it's not about renewable energy. It's about who's paying the costs associated with complying with the Renewable Energy Act. And so from my perspective, this case is all about money as opposed to renewable energy specifically. I would also note that when you talk about settlement between the parties, that ratepayers are notably not represented here. The Attorney General is not part of this case. And therefore, in a settlement process, how the ratepayers' interest is protected, I would argue, is through the deferment of some of these, what I would call substantial issues.
Ms. Souls, let me interrupt you for just one moment. So this proceeding today is about the stipulation and about,
Yes.
so it's not the case on the merits.
Yes.
And the two statements you've just made, the legal arguments you've made, sounded more like merits arguments rather than in support of the stipulation arguments.
Well,
So
in support of the stipulation, one of the legal requirements is the conclusion that it serves the public interest and that it balances the interests of the parties. And my legal argument would be that ratepayers are that shadow party in all of these proceedings in front of the commission. And as such, it is appropriate to defer some of these issues that could be argued as substantive issues. And therefore, providing the mechanisms that are in the stipulation that have to do with the money involved in the renewable energy things is an appropriate way to protect the public interest. And so some of the reasons that what happens with the money is up in the air has to do with pending cases, like the Supreme Court case regarding the CRLEF case, like the rulemaking in front of the commission that has to do with the recs from the DG and who pays for them. It is all about money. The one glaring one that doesn't fall in that category, as discussed by Ms. Stevens and Ms. Olson, is the one that has to do with the large customer count. And deferring the large customer count so that the large customers can be part of this, to balance the interests and to serve the public interest, has to include the recognition that the other side of that argument is ratepayers, not El Paso electric, it's ratepayers in terms of who is responsible for that bill. And my conclusion is that it does serve the public interest and balances the objectives both in statute and rule to defer that issue to a future proceeding, even though that doesn't settle what I would describe as a substantive issue. And therefore, it is my conclusion and my recommendation that the commission should approve this stipulation while clearly keeping these questions of who ultimately pays these costs, keeping those issues open and required to be addressed in the future.
Thank you, Ms. Souls.
Mr. Hearing Examiner,
Yes, Mr. Black.
I'm sorry to interrupt. With all due respect to Ms. Souls, I really appreciate her comments and her concluding averments. I did want to direct the hearing examiner's attention to the New Mexico statutes annotated 8-8-12, paragraph C, we quote, "The utility division shall represent the public interest in utility matters before the commission and may present testimony and evidence and cross-examine witnesses. In order to represent the public interest, the utility division shall present to the commission its beliefs on how the commission should fulfill its responsibility to balance the public interest, consumer interest, and investor interest." Thank you.
Thank you, Mr. Black. Well, since Mr. Black has got another bite at the apple, Ms. Stevens, do you have anything else you'd like to add?
I was going to try to bite my tongue on this one, but I do.
Okay,
have
that's
to-
fine.
I can't. I do have to say along the same lines that the city of Las Cruces has frequently, not in this case because we were in short time, but frequently tries to intervene in commission cases and explicitly state that we are representing ratepayers. We do believe that we are representing ratepayers. Again, this one, we were in a rush, so we didn't put that in our intervention motion in this case. And the commission repeatedly bats us down by avoiding the question, saying, "Oh, you're in the case anyway, so it doesn't matter." But I would.
That's another case, Ms. Stevens.
I would beg to differ with the idea that ratepayers are not represented. I think Ms. Souls herself is here to represent ratepayers. I know that the city is here to represent ratepayers, and I understand that staff's role is a little more ambiguous because they're supposed to balance ratepayers and shareholders' interests, and that leaves them in a little bit of a quandary as to just how far they can advocate. And historically, when it's just staff and the company, they go more to the ratepayer side, and tend to be a little more neutral when there are other parties representing ratepayers. But I agree that basically by agreeing to defer these issues to either the rulemaking, which would be ideal for the DG Rex, I believe, because of the implications, and the other questions, they are money. We are trying to. The stipulation tries to put some wrappers or some constraints on the money by, postponing resolution of the large customer issue, but also totally at the company's discretion, because the commission explicitly ruled otherwise in last year's case, stopping collection of the CRLEF recs. There's a sort of a rough, I hate to use that word, a rough justice, an appreciation of everybody, I think all the parties, that if we don't let numbers get way out of hand, we can manage them in a future case. Whereas if we keep building up the tab one way or other, that may have undesirable consequences down the road.
Thank you, Ms. Stevens. I'll make a comment before we open for Ms. Olson, but a part of my job is to listen to what people say, and a part of my job is to listen to what they meant to say. And it gets a little confusing sometimes, but I try to hear what people mean. And Ms. Souls is not a member of the bar, and I try to listen to what she means. And I actually think, and she can correct me, but she meant that the ratepayers don't have a lawyer present exclusively burdened with the duty to represent the interests solely of the ratepayers. Is that what you meant, Ms. Souls?
Yes, sir. Thank you for that.
Thank you. Okay. So, Ms. Olson, I'm going to presume that you're not going to tell me you represent the ratepayers.
I mean, I think we all respectively
Well-tempered.
doing what's best for EPE's customers. That is an effective business model. And so in that vein, I would say, yes, we're doing what we think is in the customer's best interest. I agree with Mr. Black. I would note that the motions to intervene in this case, expressing the interests of parties representing and speak for themselves.
Okay. Thank you, Ms. Olson. I didn't expect a much more of an explanation, and I agree. You got to have customers. Anyhow, I do not believe there's anything further we need to comply with or to do during this hearing. But I'm open if you think there's anything I've missed or anything that you would like to add. I'll start with the applicant, Ms. Olson. Is there anything further we need to do in this hearing?
Hearing examiner, I think it would just be helpful if you could give us a glimpse into the future of what we can expect in this case. But otherwise, I think as far as presentation of evidence and argument, I'm satisfied.
This is one of those quick 90 days that's been extended for another 90, isn't it?
I believe that's correct.
Yeah, I think so too. Does anybody remember right off the bat what's the time limit for the commission's order? I worked this out at one point, but I don't have it right in front of me. It's buried in my file somewhere.
I believe it's November 8th, so it would be November, maybe I don't have that date right. November 8th is a Wednesday.
Well, my reason I'm asking that because I am driven by that time schedule, and I have to prioritize what I do, and this would get booted up to the top of the pile if I'm constrained by that time schedule.
I apologize. I think it's November 5th. So
November-
the preceding Wednesday would be November 1st.
Right, and thereby I would want something to the, I would want not an RD, but the certification. Let's see, the commission would meet on the 3rd. I would want the certification in no later than October 20th. So that's not much of an insight, but that is an insight that it's not exactly exigent, so to speak. Any other comments or any other thing we could address at this point in the proceeding before we conclude? Ms. Stevens, can you think of anything?
No, sir.
All right. Succinct. Mr. Black.
Other than staff's waiver of exceptions to a certification of stipulation.
Absolutely,
further
my
comment.
yellow sticky
Yes.
pad.
Oh, yes.
If it's recommended, and by the way, I read the stipulation and there's a kick out clause in there. If any part is not accepted in its entirety, it's voidable by any stipulating party. I couldn't miss that one. 2.6 on page 8. So it would have to be approved in its entirety. Now, presuming it's approved in its entirety, will, with that contingency, do the other parties, by Ms. Stevens, Ms. Olson, Ms. Olson, do you agree not to file exceptions, waive exceptions
The city would waive exceptions, yes.
in that circumstance? Yes, Ms. Olson?
Yeah, we wouldn't, we would waive filing exceptions to a certification of the stipulation as proposed.
Okay, Ms. Souls, you understand, of course.
Yes, sir. I
Thank
would
you.
waive exceptions.
You waive exception as well. So that may be very helpful to get things moving along. We might get in a week earlier or even 2 weeks earlier with a final order from the commission, and that's a good thing. So thank you very much, everyone. Ms. Souls, is there anything else we should cover before we conclude our hearing today?
No, sir, I'm satisfied.
Thank you, ma'am. I am satisfied, and because we have Mr. Chavez with us, thank you, sir. Mr. Provencio, thank you, sir. Miss Pleasant, thank you, ma'am. And Mr. Martinez, thank you. The interesting thing for you guys, I feel like I already know you because I get to read your testimony, especially most recently in this case, but also in other cases. So even though I don't get to talk to you much or hear much from you, I do feel like I know you from reading your testimony. So I appreciate that, and I appreciate you being here today. It's fine. With that, I'm going to close this hearing. It's about noon. Forever hold your peace if you don't speak up now. Okay, goodbye. Thank you all. Miss Gonzalez, we're off the record.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you. You don't have to write all those thank yous, Miss Gonzalez, because we're off the record.
We are. Thank you so much.
Thank
Bye
you.
now.
Bye-bye, everyone. I don't have any rush on this case, even though, they might think it's a rush and it might seem like a rush. We don't need the transcript tomorrow or anything like that in the ordinary
I understand.
course.
Just the ordinary course. I did understand that.
When
Thank
do
you.
think that might be? Just to make sure it's quick enough.
I think by contract, it has to be within 10 days, but I'll probably get it sooner than that.
Well, obviously sooner would be fine. 10 days would be sufficient for me to do what I need to do. And I can even, usually I can, if you want to see behind the curtain, I can usually start what I need to do even without the transcript, but I like to have that transcript sometimes to verify my memory.
Very good. Yes,
And keep that off the record as well.
I'm off.
Oh, Miss Stevens is listening.
Okay.
Okay.
All right.
Everyone have a
Thank-
wonderful day. Thank you very much.
Thank you
Bye-bye.
so much. Bye-bye now.
And thank you, everybody in YouTube land. Goodbye to you as well.